Welcome back to Winning Isn't Easy. I read every disability case that comes out in the United States every week, and I find that these court cases really teach me not only about the law, but how judges think about cases and the tactics and strategies that carriers will employ to try to delay and deny people who have disability claims the rightful benefits that they're due and owing. Sometimes these court cases read like mystery stories, sometimes they read like horror stories, and sometimes they read like a fairy tale. Today, I'm going to tell you the story of James Lewis. He was employed by Oracle as a senior principal product strategist. Now, he began intermittently missing work, but nothing with enough frequency to satisfy his 90-day elimination period. And Oracle terminated his employment on October 13th, 2017. He filed a claim for disability benefits, which unfortunately was denied. So the 90-day elimination period for his claim began on October 13, 2017, and it ran through January 10, 2018. So that's October 13, 2017 through January 10, 2018. Hartford Life, the disability carrier, reviewed his medical records in that particular time frame. Unfortunately, he got spotty medical treatment. He really didn't visit any of his treating physicians for the first 55 days of the elimination period. And his doctors really couldn't provide any objective evidence of his disabling medical condition or continuous total disability through the elimination period. So you can imagine that he was not happy when his claim was denied, and ultimately he sued. And I'm going to tell you about what the court did in the case of Lewis versus Hartford Life. It's a case out of Washington State. And the court upheld that claims denial because they found that the medical proof was not sufficient to establish, based on an objective evidence, that his disabling medical condition kept him totally disabled through the elimination period. Now, had Mr. Lewis gotten medical care and had his doctor supported his claim, I think we would have gotten a completely different result. And of course, he would have had to have met that 90-day elimination period. I know it can be really tough for people to make that decision to stop working and apply for their benefits. And some people will do a stop, they'll do a start, they're not sure, they want to give it their best. But that can potentially be held against you. And as I told you the story in the last segment, I actually had one of my clients who was terminated by her employer during the elimination period, notwithstanding the fact that she had tried to work, had not been successful, got some medical care, and was bound and determined to come back and work for her employer. And they ultimately terminated her during this elimination period, and she wasn't entitled to her benefits. So this elimination trap can really destroy a claim before it gets out of the box, because more often than not, if you are still covered by your carrier's policy and you go back to work, you're going to start all over again with a new elimination period. And hopefully by that point in time, you'll have consulted with an experienced ERISA disability attorney and understand what the length of the elimination period is, whether you can work, and if so, how you can work in a way that does not result in a denial of the claim or having all those days tacked on to the end of the elimination period and having to go even longer to satisfy the elimination period. Well, that's it for this episode. If you like this podcast, consider liking our page, leave a review, or share it with your friends and family. Remember, our podcast is weekly, so stay tuned for our next episode in the coming week. Take care.